many of you have struggled with the problem of how to handle bad facts in your car crash cases? How many of you believe that if the bad fact is coming into evidence against you, it's best that you put it into evidence first before the other side does? How many of you think that if you put the bad fact in first, you may be magnifying it, you may be conceding its material, and sometimes at least it's best to wait and respond until after the other side puts it in? Why do we have these strongly held beliefs about dealing with bad facts? One explanation potentially is the so-called just world hypothesis. What's that? The just world hypothesis is what we all want to believe. Bad things don't happen to good people. That's what our jurors want to believe. So if you're representing someone who's injured and they're sitting in front of the jury, the jurors want to believe if something bad happened to this person, the person isn't good. Because in the just world, God or the deity or whoever does not let bad things happen to good people. We all want to believe that. And so why does that matter when we deal with our cases, when we put together our themes, when we take depositions, when we cross-examine defendants? Why do we need to be aware of that when we pick the jurors? Why do we need to be thinking about the just world hypothesis? Because the jurors are going to be engaging in something called defensive attribution. What's that? Attribution, attributing something to somebody. Defensive is protective. I'm attributing blame to this injured plaintiff to preserve the belief that I and my loved ones will not suffer a similar fate. It means if I'm following the rules, if my family member's following the rules, if we're going straight on a green, do you mean to tell me on this jury that we can be crunched and killed by an 18-wheeler? Well, that's a conflict. That conflicts with my need to believe in a just world. Now, many people believe that jurors who are similar to the plaintiff are going to be better jurors for the plaintiff. They're going to be more likely to identify for the plaintiff. If I represent a young mother who was injured, wouldn't other young mothers be the best jurors on my case? Isn't that the conventional wisdom? And the identification effect, the studies that show this effect, turn that on its head. And the paradox is these studies show that, not as predicted, jurors who are similar to the plaintiff don't place less blame on the plaintiff, they place more blame on the plaintiff. Why? Why would that be? Why would that make any sense at all? There was a case study with a 5-year-old who was injured in a shopping center. And in that case study, guess which focus group jurors were most likely to blame the mother and the child for the injury? Other mothers with children. Why would that be? Because other mothers with children want to believe my child cannot get injured unless I'm not watching that child. That comforts me if I'm a mother. And this mother and this child who are here in this courtroom, they must be here because that mother was not watching her child. So what's the bottom line? Well, one of the easy bottom lines is in every veneer panel that you deal with, you've got a group of jurors who were injured who did nothing about it. You must find them because most people who are injured do nothing about it, and they're critical of the people who do something about it. Let's talk about another effect, the severity effect. In a nutshell, the severity effect is this. As the severity of the injury goes up, all things being equal, the need for the jurors to blame the victim goes up. The victim's going to be found more blameworthy, all things being equal, when the outcome is severe. Why? Well, the authors of the study said the jurors didn't focus just on victim blameworthiness, needless to say. They were focusing on other things. And why might these jurors, these focus group jurors, have been doing that? Because they were engaging in something called hindsight bias. They knew the outcome. They knew if Brogdon was going to try and run across on a yellow light, he was going to be killed because they were given that fact. And unfairly, they attributed that knowledge to Brogdon before he ran across the yellow light. Versus when Brogdon's only bruised, they attributed, well, Brogdon knows he's only going to be bruised. Obviously, that's not fair, that's not logical, it's not correct, but it is going on in jury deliberation rooms, and you need to be aware of it. So the bottom line on defensive attribution is it doesn't explain all of the biases that are back there going on in the jury deliberation room, but it is something, it is one of the very important biases that we, as lawyers for the victim, need to be aware of and need to focus on. So we've now discussed some things and some reasons why jurors assign blame using bad facts, but what can you do about that? There's a book, a really good book, How Risky Is It by David Rappelk, and he outlines the factors, and I think these are useful when we pick jurors, when we choose our themes in our cases, when we're dealing with bad and good facts, factors that determine whether people are fearful. First, do we trust the entity involved? Aspirin has a lot of benefit, but people die from aspirin every year. But try and convince a jury that aspirin is a defective product. Everyone has in their brain, aspirin is a great medicine. It helps save lives. It reduces pain. Yeah, some people die, so be it, is the thought. Control. Do I control it? Elective surgery versus non-elective surgery. Natural versus man-made. If it's a man-made risk, it's perceived to be more risky. Pain and suffering. If there's more pain and suffering, we're more afraid of it. Uncertainty, more afraid of it. Can it happen to me? If yes, risk is more. So that's the kind of thing you need to be thinking about it. So how do you deal with it? Inoculation or what's called sponsorship. I'm going to call inoculation any theory that you put in the bad fact preemptively. If you force someone not to be able to inoculate, the jury may penalize them by thinking they're not telling the truth. If you concede first, you can be forgiven. Others say, when you inoculate, you can choose when to do it. Is this bad fact coming in right before they go home on a Friday when they can stew about it all weekend? Or is it going to come in after lunch when they're sleepy and you're going to put in some other facts? And then the other thing is put in the good facts first, put in that bad fact, and then end strong. Start strong, inoculate with the bad fact, and end strong. Primacy and recency, we've all heard about that. How large is the weight of authority behind inoculation? Quite frankly, it's overwhelming. But there is a competing theory called sponsorship theory. Sponsorship basically derives its name from the idea when you put in evidence, you are sponsoring it. We have been reflexively inoculating, putting in bad facts first, and we don't need to do it. And when we do that, we're doing two bad things. We're conceding its material, because the jurors are looking going, why is Brogdon putting in evidence that hurts him? He must think it's important. And we're magnifying the harm, Klonoff and Colby said, because we're spending time on bad facts. And the jurors focus on what we spend time on as trial lawyers. Sponsor meaning introduce. Sponsor just means introduce. Sponsor bad facts, sponsor evidence only if the benefits outweigh the risks. And then there's a strategy. You're supposed to constantly be trying to shift the costs of admitting evidence to the other side. What are the costs of admitting evidence? You're conceding its material when you admit it, and you're magnifying any harm that's within the evidence when you admit it. What should I do? Well, the first thing you always want to do is turn the weakness into a strength. Turn the weakness into a strength. Yeah, my client didn't seek medical attention at the scene. She didn't say, oh my God, I need to leave in an ambulance. You know why? Because she had no agenda to pursue a lawsuit. Yes, she did go back to work the Monday after the crash. Why? She had no agenda to pursue a lawsuit. Yes, she toughed it out. Yes, she waited 2 weeks before she went to the doctor. Why? She had no agenda to pursue a lawsuit. Oh, she was hurt before? Oh, yes, she was. And did she file a lawsuit when she was in that previous crash and she hurt her back? No. Because, why? She had no agenda to pursue a lawsuit. So take the weaknesses and turn them around. limiting instructions. When bad evidence is admitted over your objection, and you want to appeal later, you probably need, under Rule 105, Texas Rule of Evidence 105, to tender to the court a limiting instruction. Judge, I'm requesting that you instruct the jury that this evidence is admitted only for the purpose of X, Y, and Z. If you want to offer bad evidence on the other side and the judge excludes it, you have a duty, most appellate court case says, to re-offer it with your own limiting instruction. Judge, I offered this with no limiting instruction. You excluded it. Now I'm re-offering it with a request that you give an instruction to the jury that they consider this only for the purpose of deciding whether the defendant did X, Y, or Z. Are you waiving your right to appeal based on the admission of the bad evidence? And so there are two hurdles in Texas: preserving error and waiver. Preserving error is, do I object at square one to the admission of the bad evidence? My client has a criminal record. I'm objecting. Am I preserving error? Remember, limines do not preserve error. File a motion for pretrial ruling on admissibility of evidence. File it early, weeks, months before your trial, and have a hearing on it and style it that way. But then the question is, even if you do that, do you later waive it when you put it in yourself? And unfortunately, the weight of the opinion in Texas is yes. There's some amendments to Rule 103 that appear to imply that you can have your cake and eat it too. But there's a long-standing body of case law that says limines do not preserve error. So do not rely on that. But just know, if you're going to inoculate, you're probably giving up in Texas the right to appeal on that basis. And so I hope my talk here today has given you a little different way to think about handling the bad facts in your cases, bad facts that we all have. It's fashionable not to admit that we have those bad facts in our cases, but we do. The cases that go to trial inevitably have bad facts in them. I hope that I've helped you think about them a little differently. Thank you very much.